Friday morning, the Supreme Court delivered a landmark ruling in Obergefell v. Hodges. The Constitution guarantees same-sex couples the right to marry. The case specifically required the court to address a state's right to ban same-sex marriages and whether a state must recognize marriages made legal in another state. By ruling 5-4 that states cannot ban and must recognize those unions, the court made same-sex marriage legal in all 50 states, delivering a huge victory in the hard-fought battle for equal rights. Writing the majority opinion, Justice Kennedy said this of same-sex couples seeking marriage licenses: their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right. There was celebration in front of the Supreme Court as news of the ruling spread, and President Obama, who publicly endorsed same-sex marriage in 2012, spoke from the White House Rose Garden.
What an extraordinary achievement. What a vindication of the belief that ordinary people can do extraordinary things. They should be very proud. America should be very proud.
Before Friday, 37 states and the District of Columbia had already made same-sex marriage legal. And an April 2015 poll shows more than 60% of the population support same-sex marriage. And while the court's decision does not align with popular opinion, the justices does align with popular opinion. The justices did split 5-4, showing that division still exists. One probate judge in Alabama even stopped issuing marriage licenses altogether since the state legalized same-sex marriage. Responding to the Supreme Court ruling, Judge Wes Allen said, "My office discontinued issuing marriage licenses in February, and I have no plans to put Pike County back into the marriage business. The policy of my office regarding marriage is no different today than it was yesterday." So while Friday's ruling represents a meaningful victory, it's clear the struggle continues. Joining me now, Kenji Yoshino, Chief Justice Earl Warren, Professor of Constitutional Law at NYU School of Law and author of Speak Now: Marriage Equality on Trial. Man, I'm glad you took some time off and finished that book before this extraordinary moment. Tell me a little bit about Justice Kennedy's decision. What did you read there?
I really read Loving versus Virginia Redux. So I think he tipped his hand when he said in oral argument, which I attended on April 28th, that doesn't this case, Obergefell, bear the same relationship to Lawrence, often called the Brown v. Board of the gay rights movement, which struck down sodomy statutes, as Loving did to Brown. So he explicitly compared this case before us today to Loving versus Virginia, the 1967 case that said that the right to engage in an interracial marriage was legal across the land, washing out, I think 16 states at the time when it was decided. So very, very analogous to, in terms of the numbers, to what happened today. But I think more importantly, Melissa, like he said, this is not only about liberty, it's also about equality, and the two things interlock. And the key thing about Chief Justice Earl Warren's opinion in Loving was that he said this is not only about the freedom to marry, it's not only about the right to equality for African Americans, it's about, or all racial minorities, it's about everybody. So he made the two things come together. And I think that this opinion wasn't as explicitly patterned on Loving versus Virginia as other opinions have been, but it really had that kind of heft and soaring rhetoric in it.
It feels sometimes like the universe is purposely trying to keep us from being too reductive in our analysis of that arc of history moving towards justice. The idea that we were burying in Charleston, South Carolina, the victim of a racial hate crime at the same time that we have this enormous and meaningful decision occurring in the courts. And I am wondering about the ways in which not only the courts, but sort of the movement sits at that intersection of successes and failures all at the same time.
Yeah, so I love your line, which I know comes from your dad, about how the struggle continues. I mean, Kevin Cathcart of Land O'Legal once said that there have been many civil rights movements that have begun, but no civil rights movement has ever ended, right? So, and as Mike Signorelli says in his great new book, It's Not Over, there's a lot of, running room or progress that still needs to be made in the gay rights realm itself, right? So I actually think that the struggle is going to still continue with regard to, say, the 29 states that still have still lack employment discrimination protections for gay rights. We were talking about whether you could eat at Chick-fil-A.
I did. I said, can I go back to Chick-fil-A? I really want my waffle fries back. And you were like, nope, sorry.
Or the Religious Liberties Act, or the 200 nations around the world that still lack marriage equality, the 70 nations around the world that still ban sodomy, the 8 of those countries make that sodomy punishable by death, right? So there's a really long road ahead there as well.
Is there anything in this decision that might give some idea of what the successes of those continuing struggles within the question of rights for gay, lesbian, and transgender people might look like as the movement moves in that direction? Yeah,
that's a wonderful question. Thank you for asking it. So a couple of things. One is that with regard to the religious liberties defenses, Chief Justice Roberts, in his dissent, pointed out that Justice Kennedy didn't leave much running room for people with religious objections to same-sex marriages. So I think that's a really important protection for gay rights on the there's no religious right to discriminate point. Second, you noted that the strategy of like closing the swimming pool rather than integrating it. So like, I'm not going to grant marriages to anybody because I don't want to grant them to gay people. That strategy, I think, was defeated by a very clever move in Justice Kennedy's opinion, where he talked about liberty rather than equality. Because if you're just talking about equality, let's think about this for a second.
So then no public pools for anybody, no marriage for anybody.
Exactly. You can level down as well as level up. But once you say there's a fundamental right to marry, you can't level down anymore. And so there's no fundamental right to use a public pool. This is actually, as you know, but your viewers may not know, an actual case, right, where Jackson, Mississippi said we'd rather close our swimming pools, all of our public swimming pools, than to integrate them, and that was upheld by the United States Supreme Court as totally comporting with the Equal Protection Clause because they're treating everybody equally.
Yeah, but marriage.
But there's no right to use a public recreational facility, but there is a right now, you know, to marry for same-sex couples, so you can't level down in the way that, you know, the Alabama County is seeking to do.
It's a big win. Kenji, stay with us. We're going to add more voices because there is more to talk about on this and so much more when we come back.